Good morning, Chairman Grassley, Ranking Member White House, and esteemed senators of this committee. My name is Cornell Brooks. I serve as President and CEO of the NAACP. I greatly appreciate the invitation to testify before you today and to express the deep concerns of the NAACP regarding the nomination of Senator Jefferson Sessions to be U.S. Attorney General. As you well know, the Attorney General is the Chief Law Enforcement Officer of the United States. Particularly for such a time as this, with racial divisions deepening, hate crimes rising from sanctuaries to schoolyards, with state-imposed, racially motivated voter suppression spreading in state legislatures, as well as being struck down in federal courts, with police-involved shootings reduced to hashtag homicides and viralized videos. It is critical that this committee closely examine Senator Sessions' entire record as a prosecutor and as a legislator to determine whether he is fit to serve as the chief enforcer of our nation's civil rights laws. Based upon a review of the record, the NAACP firmly believes that Senator Sessions is unfit to serve as Attorney General. Accordingly, we representing multiple civil rights and human rights coalitions, we urge this committee not to favorably report his nomination to the full Senate. As our written testimony details, Senator Sessions' record reveals a consistent disregard for civil and human rights of vulnerable populations, including African Americans, Latinos, women, Muslims, immigrants, the disabled, the LGBT community, and others. Further, his Senate voting record reflects a fundamental disregard for many of the Department of Justice's programs, which are vital for the protection of Americans. Senator Sessions votes against the Hate Crimes Prevention Act of 2000, 2002, 2004, 2007, and 2009, and the Violence Against Women Act in 2012 and 2013 demonstrate a disturbing lack of concern regarding violent crimes, rape, assault, murder committed against minorities and an American majority women. These crimes in particular make victims of individuals as well as the groups to which they belong and the American values we cling to. His opposition to the Lilly Ledbetter Fair Pay Act indicates a hostility to the claims of employment discrimination and more specifically to allowing legal redress for pay discrimination against women. His consistent opposition to any meaningful gun control shows an unwillingness to stand up to the firearms lobby and a lack of concern regarding the destructive impact of gun violence on our children and communities. His failure to condemn the President-elect's call for an unconscionable and unconstitutional ban on Muslim immigrants, as well as his opposition to a Senate resolution condemning a government-imposed litmus test on a global religion, evidences an unwillingness to protect the rights of the vulnerable and the unpopular, which is something an Attorney General must do. His call for the reevaluation of a basic constitutional principle that persons born in this country are citizens of this country reflects a form of an unconstitutional xenophobia that is fundamentally inconsistent with the duty of the Attorney General to protect the rights of all Americans. His calling into question the legitimacy of consent decrees causes us to question whether he will use this powerful tool to hold accountable police departments such as Ferguson that engaged in predatory policing and a pattern and practice of discrimination. With his consistent support for mandatory minimums as a prosecutor and a legislator, he stands in opposition to bipartisan efforts to bring to an end this ugly era of mass incarceration with 2.3 million Americans behind bars, with overpopulated prisons and jails and depopulated families and communities. It is Senator Sessions' record on voting rights, however, that is perhaps the most troubling. As this committee is well aware of the infamous Marion 3 case in which civil rights activists were prosecuted by then U.S. Attorney Sessions for voter fraud, all of whom were acquitted by a jury in less than 4 hours on 29 counts. This chilling prosecution against innocent civil rights workers who were later given gold medals by Congress painfully reverberates in the hearts of black voters in Alabama and the history of this country. Senator Sessions' record of prosecuting so-called voter fraud and both intimidating and suppressing voters then is now reflected in a legislative record of supporting voter ID requirements that suppress votes based on the myth of voter fraud today. His record of vote-suppressing prosecution is connected to a vote-suppressing legislation today. Rather than condemn, he's commended voter ID laws like that in his own state of Alabama affecting 500,000 voters, similar to laws struck down in Texas and North Carolina in the 4th and 5th Circuits. If we can imagine Senator Sessions leading a Department of Justice in Michael Brown's Ferguson, Freddie Gray's Baltimore, towns with rising hate crime, communities of vulnerable populations, and a democracy divided by voter suppression in this Twitter age civil rights movement. We can imagine that. Imagining that, we must face the reality that Senator Sessions should not be our Attorney General. With that said, thank you for this opportunity to testify. I welcome your questions.